My name is Ala Suhaila. My metric number is 20DPA30083F1001.
Hi, my name is Naim Ataullah bin Sharif. My metric number is 20DHG23F1051.
Hi, my name is Kausalena Sarida Anapiloksau. My number matrix is 20DAT23F1049.
Hello, my name is Muhammad Fikri Nuriman bin Azari. My matrix number is 20DAT23F1021. I'm the fourth presenter.
Hi, my name is Muhammad Zilazi bin Zamri. I'm from class DAT3A and my metric number is 20DAT23F1033.
For question 1A, Section 2, Subsection 1 of Companies Act 2019, financial statement has the same meaning as set out in the approved accounting standards issued or approved by the Malaysian Accounting Standard Board under the Financial Reporting Act 1997. For profit and loss account includes income and expenditure account, revenue account, or any other account showing the results of the business of a corporation for a period. Then, a balance sheet is a financial statement that shows a company's asset, liabilities, and equity at a specific date. It tells what the company owns, and how much belongs to the owners. In Section 266, Subsection 1 of Companies Act 2016 state every auditor of a company shall report to the members on the financial statements and on the company's accounting and other records relating to those financial statements, and if it is a holding company for which consolidated financial statements are prepared shall also report to the members on the consolidated financial statement. Next, for auditor requirements for public and private company. For public company, first one is must be listed as public companies. Next, mandatory, no audit exemption. Under Section 271, Subsection 1 of the Companies Act 2016, an auditor must be appointed for each financial year of the company. Next, for private company, mandatory for private limited companies except those meeting audit exemption requirements under Section 267 of the Companies Act 2016. Next, for exemption of appoint an auditor. Under Section 267, Subsection 2 of the Companies Act 2016, the registrar may exempt a private company from appointing an auditor according to certain conditions. Three types of private companies exempt from audit. First, dormant companies. Second, zero revenue companies. Third, thresholder qualified companies. Next, criteria for private companies to be exempt: annual revenue does not exceed at RM 3,000 ringgit, total asset does not exceed 3,000 ringgit, and numbers of employee does not exceed 30. For audit, meaning is to express an opinion on whether the financial statements are prepared according to the reporting framework and free from material misstatement, provide high assurance of accountability. The objective, to certify the correctness of financial position, balance sheet, and income statement, to detect errors and to detect frauds.
Internal audit. Divided into audit committee and internal auditor. Consists of internal control mechanisms set up by the company. External auditor. A. External auditor appointed by the company's shareholder. B. Has extensive duties and obligations to the shareholder, company, and a third party. C. Objective of audit. And the last one is company auditor are the not official of the company. Section 264 Company Act 2060. Company auditor. Subsection 1. A person shall not, Subsection A, knowingly consent to be appointed as an auditor for any company. Subsection B, knowingly act as an auditor for any company. Subsection C, prepare for or on behalf of a company any report required by this act to be prepared by an approved company auditor. If Roman 1, he is not an approved company audit, or Roman 2, he is indebted to the company or the corporations. This is to be related to the company by virtue of Section 7 in an amount exceeding 25,000 ringgit. Roman 3. He is Subsection A, or he is supposed into an officer of the company. Subsection B. A partner, employer, or employee of an official of the company. Subsection C. A partner or employee of an employee of an official of the company. Subsection D. A shareholder, or his is a shareholder of a corporations. Employee is an official of the company. Roman 4. He is responsible for, or if he is a partner, employee, or employee of a persons responsible for the keeping of the register of the member or the register of debentures holder of the company. Roman 5. He is undischarged bankrupt within or outside Malaysia, respect with a leave of the country. The court or behavior. Roman 6. He has been convicted any offense involving fraud or dishonestly with imprisonment 3 months or more. Methods of appointment. Private company according to Section 267, Subsection 1, Company Act 2016. An auditor should be appointed on every financial year of a company. Section 267, Subsection 3, the board shall appoint an auditor of the company. Section A, in the case of a newly incorporated company, at least 30 days before the end of a period of the submissions of the first financial statement on the register. Subsection B, to fill a casual vacancy in the office of auditor. Section 269, term of office of auditor of private company. Subsection 1, an auditor of a private company shall hold office in accordance with the term of his appointments, provided that Subsection A, he does not take office until the previous auditor ceases to hold office, unless he is the first auditor of the company. Subsection B, he ceases to hold office 30 days from the calculations of the financial statements to the member unless he is reappointed. Next, public company. Section 271, appointment of auditors of a public company. Subsection 1, an auditor of a public company shall be appointed for each financial year of the company. Subsection 2, notwithstanding Subsection 1, the board shall appoint an auditor. Subsection A, at any time before the first annual general meeting of the company. Subsection B, to fill casual vacancy in the office of the auditor. Subsection 3, any auditor appointed under Subsection 2 shall hold office until the conclusion of Subsection A, the first annual general meeting for appointments under paragraph Subsection 2, Subsection A, or Subsection B, the next annual general meeting for the appointments under paragraph 2, Subsection B. Next, Section 273, term of office of auditor of a public company. The auditor of a public company shall hold office in according with the term of his appointment, provided that Subsection A, he does not take office until the previous auditor has a cases to hold office unless he is the first auditor of the company, and Subsection B, he ceases to hold office at the conclusion of the annual general meeting next following his appointment, unless he is reappointed. The last one is section 270. Preference by members of teams reappointed of auditor. Subsection 1. An auditor of a private company shall not be to be reappointed under subsection 269, subsection 3, if the company has received notice under the section from the member representing at least 5% of the total voting right of a member who would be entitled to vote on a resolution that the auditor should not be reappointed.
Question 3. Qualification of an auditor. A. Approval and validity of approval by the Ministry of Finance. Section 263 of the Companies Act 2016. Company auditor to be approved by Minister charged with responsibility for finance. Subsection 1. Any person may apply to the minister charged with the responsibility for finance to be approved as a company auditor for the purpose of this act. Subsection 2. The minister may, if he is certified that the applicant is of good character and competence to perform the duties of an auditor under this act, upon payment of the prescribed fee, approve the applicant as a company auditor. Subsection 3. Any error granted by the minister under subsection 2 may be made subject to such limitation of condition as he thinks fit and may be revoked at any time by him by the service of a notice and revocation of the revoked person. Subsection 4. Every approval under this section, including a revolt of approval of a company auditor, shall be in force for a period of 2 years after the date of issue unless soundly revoked by the minister. B. Several requirements under Section 264 of the Company Act 2016. Section 264. Company auditors. Subsection 1. A person shall not. Subsection A. Newly consent to be appointed as an auditor for any company. Subsection B. Newly act as an auditor for any company. And subsection C. Prepare for or on revolve of a company and report required by this act to be prepared by an approved company auditor if 1 Roman he is not an approved company auditor. 2 Romans he is indebted to the company or to the corporate that is deemed to be related to that company by virtue for Section 7 in an amount exceeding 25,000 ringgit.
Hello, my name is Muhammad Fikri Nuriman bin Azari. My matric number is 200DPA30083F1021. I'm the fourth presenter. For question 4, A. Duties under Companies Act 2016, Section 266, Subsection 2 and Subsection 3 of the Companies Act 2016. The auditor must report to the members on the financial statement examined by him The report shows that whether the financial statement give a true and fair view of the company's financial position and performance. The auditor must comply with approved auditing standard. The auditor has the right of the access all reasonable time to the accounting and other records of the company. The auditor may require any information and explanation from the officer of the company as he consider necessary for audit process. The auditor must from an independent opinion and report any material misstatement or non-compliance found. For the case is case Tioh Bank PV .1 and Co. 2005 ML 149. The court held that auditor owed a duty to exercise reasonable care and skill as professional. A failure to do so constitutes negligence under the Company Acts. Next for B, duties under the common law. For the Romans 1, duty to shareholder. The auditor owns a duty to the shareholders collectively as a body, not to individual shareholder. The auditor role is to enable shareholder to exercise control over the company's management based on true financial information. For the case is London and General Bank number 2, 1895. Auditor must ensure that the financial statements are not misleading and must report honestly to the shareholder. For the Romans 2, duty to the company. The auditor owes the duty to the company as the whole to carry out the audit with care, competence, and independence. The duty is to detect material misstatement and report correctly. And for Romans 3, duty of care and skill. Auditor must perform their work with reasonable care, skill, and intelligence expected from a professional auditor. For the case Patrick Tay v. Public Accounting Board 2002, establishes that auditor must adhere to professional standards and exercise professional care in their audit duties. For Romans 4, duty to third parties. Generally, auditors do not own the duty to third parties unless a special relationship exists. For liability to third parties, certain conditions must be met. One is the auditor must know that the third party will rely on the report. For two, the reliance must be reasonable and foreseeable. For three, there must be a sufficient degree and promiscuity. For the case is corporate industry, the Dickman, 1990, no duties care to investor who relied on financial statement for personal investment decision. Next is case Hadley Brain v. Harley Partners, 1964. Duty of care arises where there is a special relationship and relying on the auditor statement is essential. For 5 is duty of confidentiality. Auditor must not disclose confidential company information obtained during the audit without proper authority or consent. Disclosure without consent is permitted only in specific circumstances, as at when required by law and court order, when reporting to regular authorities or enforcement agency, and this one is when disclosure is in the public interest possible.
According to Section 266, subsection 4, an auditor of the company has a right of access at all reasonable times to the accounting and other records, including registers of the company, and is entitled to require from any officer of the company and any auditor of a related company such information and explanation as he desires for the purpose of audit. According to Section 266, subsection 6, the auditor's report shall be attached to or endorsed on this financial statement or consolidated financial statement and shall, if any members so requires, be read before the company in general meeting and shall be open for inspection by any member at any reasonable time. According to section 266, subsection 7, an auditor of a company or his agent authorized by him in writing is entitled to attend any general meeting of the company and to receive all notice of and other communication relating to any general meeting which a member is entitled to receive, and to be heard at any general meeting which he attends on any part of the business of the meeting which concern the auditor in his capacity as auditor. According to section 266, subsection 8, if an auditor, in the course of the performance of his duties as auditor of a company, is satisfied that subsection A, there has been a breach or non-observance of any of the provision of this Act. Subsection B, the circumstances are such that in his opinion the matter has not been or will not be adequately dealt with by comment in his report on the financial statement or consolidated financial statement, or by bringing the matter to the notice of the director of the company, or if the company is a subsidiary of the director of its holding company. According to section 266, subsection 9, in addition to subsection 8, if an auditor in the course of the performance of his duties as an auditor of a public company or a company controlled by a public company is of the opinion that a serious offense involving fraud or dishonesty is being or has been committed against the company or this act by officer of the company, he shall forthwith report the matter in writing to the registrar. According to section 286, subsection 3, an auditor shall not be liable to be sued in any court or be subject to any criminal or disciplinary proceeding for any report under section 266 submitted by the auditor in good faith and in the good attendant performance of any duty imposed on the auditor under this Act.